of the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, the first case we're going to hear is Maldini versus Marriott International Court. And Mr. Hellman, we'll hear from you first.
Good morning. Thank you, and may it please the court. I'm Matthew Hellman on behalf of Marriott International. We're back here because the district court once again certified classes that consist entirely of people who agreed that they would not pursue class relief. Marriott invoked that waiver at every turn, in its answer, throughout discovery, and at class certification. There was no surprise here. And the district court's contention that Marriott somehow intentionally relinquished the very defense that it repeatedly invoked is replete with legal error. It's foreclosed by the contract's plain text and foreclosed by uniform precedent. It's also foreclosed by the history of the case. Before plaintiffs moved to certify, plaintiffs said their class claims could arise under any of 31 different contracts. Plaintiffs were insistent on keeping their options open, but Marriott still told them throughout that it would invoke a class waiver defense if applicable. And when plaintiffs chose to pursue the largest classes possible by basing them on the SPG terms, Marriott invoked the class action waiver. This case is as simple as that. Marriott relinquished nothing, let alone intentionally. So I'd like to focus on those issues first this morning, and then turn to the ascertainability and Comcast arguments that provide additional and independent grounds for reversal. So let's start with the district court's waiver analysis, which really piles legal error upon legal error. The district court believed and held that the choice of law provision in the parties' contract, which specified New York law, was waived when the parties agreed to a bellwether process that included claims and claims that apply different states' law. Marriott did not merely stay silent on choice of law issues when they did that. Marriott reserved choice of law issues. And Marriott did not merely unilaterally reserve choice of law issues. The parties jointly agreed that choice of law would be dealt with later. An express reservation of rights that the parties agreed would be appropriate to deal with later is not an intentional relinquishment of yet another right. Another part of the district.
Can I ask you a question
Please.
just about the intentional relinquishment standard? So, I mean, there's been different nomenclature, I guess, used to refer to kind of what is going on here, forfeiture, waiver, and then some references to repudiation. Does it make a difference if we move off waiver and think about the case in terms of, say, repudiation?
They all cash out to the same answer, Your Honor, because all of them are going to turn first on. There was no inconsistency, lack of, nothing was done inconsistent with the contract in the first place. That would be point number one. And all of those doctrines only work if there's some intentional or known or understood relinquishment, repudiation, whatever word, forfeiture, whatever word you want to use to describe the concept. None of them apply.
Well, I suppose we don't want to get too refined on that because there's a doctrine of implicit waiver. If you litigate the case, for instance, you have an arbitration clause and you litigate the case, we imply a waiver of that. And I suppose here, if you went ahead and maybe raised it once very early but never thereafter, there could be an argument made on implicit. But I think the principles of waiver are fairly well established. And the issue here is whether, as I understand it, whether you link the class action waiver with venue waiver or whatever, and whether you link the class action waiver or you conclude the class action waiver was waived by participating in the multi-district litigation process.
Right. And I'm happy to talk about any or all of those points. Choice of law was the first of the linkages that the district court used. The next one was venue. It is, the case law is uniform, 100%, that agreeing to an MDL or an MDL that takes place in venue one is not inconsistent with a choice of venue clause in the party's contract. We have a bunch of cases that say that. They have zero that say the
Yeah, but even
opposite.
to get to these discussions, you know, they get to collateral issues. I know the argument is that they're all contained in the same paragraph,
Sure.
the same sentence, but it seems to me if someone, if a clause provides for venue and then says you waive class action treatment, I don't know why a party couldn't waive venue and still preserve the class action provision.
Absolutely, particularly where the contract expressly says that clauses are to be treated separately in terms of their invocation. And if I could, I mean, there's a lot I could say about the analysis below, and I'm happy to go point by point.
The
But-
provision that prohibits collective handling of the claims, comma, including by class action. So it's broader than class action.
No, Your Honor, and the text is really important here. It does not say handled individually, no handling individually, including by class
I
action.
didn't say individually. I
You-
said prohibits collective handling of the claims.
It says handled individually without class action. I think I heard the word including class action. It does not say including. It does not say and class action. It defines individually handling without class action, meaning if it's a class action, that tells you it's not individually handled. And if I could, there are many arguments in the case, but I'd encourage the court to look at page JA 1066. Because JA 1066 tells you the story of this case in a way that
1066, there's a lot to
1060
look at here, isn't there?
Yeah,
You've been above 1,000.
above 1,000.
That's just of the appendix.
I know, Your
That's just the
Honor.
appendix
Right.
that you gave us.
You referred to it as a lawyer's paradise the last time we were here.
Well, it is.
And, but there are many, the case had a long, long road, but there were some things that were done right and the way they're supposed to be, and this is one of those things. When we answered in the complaint, we said we had a class action waiver defense. That's what we said, defense of class action waiver. In discovery, the plaintiffs, as was their right to do, they asked us in an interrogatory, what is the basis of your class action waiver defense? That's 1066, interrogatory number 14. List all facts supporting your contention that plaintiffs' claims are barred in this jurisdiction in whole or part by their agreement to waive participation in a class action. Marriott responds. Marriott states that by enrolling in Starwood's preferred guest program, individual bellwether plaintiffs agreed to forego participation in the class action. The terms of such agreements are produced by documents, and then there's a whole list of Bates numbers, 9 of them. 4 of those Bates numbers are the SPG terms. We didn't hint that we were going to do this. We didn't imply that we were going to do this. They asked, what is your position on class action waiver? And we told them that if their claims, as certified, would implicate these contracts and these provisions, we would invoke the waiver. So there's an element
Well,
of,
as I understand it, I don't want to advocate, but I did look at the record to some extent, even though I didn't read every page, I can't tell you that.
Right.
But it was also covered in depositions, and it was also included as a separate section on the motion for certification. There was a separate section addressing the waiver clause.
yes to all of the above. Yes to all of the above. And you know, my friend's brief on the other side doesn't use the word surprise, but that's the thrust of it, that somehow they were taken advantage of, that they didn't know that this was coming. They were told in every way that the law allows us to tell them that it was coming, and they made a strategic decision to certify classes that had SPG members. The district court then tailored the classes to consist only of people who were subject to this waiver that we said we would invoke, which is a risk that they understood that they would be taking. They're entitled to propose a class definition and see what happens with it. but they can't say that we didn't invoke this class action waiver and tell them that it was coming at every time. The last time we were here, I think what this court held was that it is normal and customary to raise a class action waiver defense at class certification. That's what we did. And then the question was, I think, going back, was there some reason to think that that wasn't a valid invocation because of conduct during the litigation? As Judge Niemeyer points out, there was no surprise, no contrary action, no anything. And again, I think it's just telling that the district court has pointed to things like a venue provision, which even if you want to indulge the assumption that somehow venue is tied to the class action waiver, notwithstanding there are different provisions and there are different sentences or different parts of a sentence, different rights, and there's a severability clause. Even if you want to indulge that assumption, it's just wrong on the law that agreeing to an MDL violates a venue provision. How could it be, if this court were to hold that, MDLs only happen when there's big-time, multi-jurisdictional litigation, usually multiple contracts. There were 31 in this case. There were different venue provisions in those contracts. There's no one venue that maps on to all contracts that are sort of out there in the wild that might have different venue provisions for different reasons.
Can I ask you just a quick
Please.
question about some of the dangling threads of this lawyer's paradise of the case? So assume, just very hypothetically, that I disagree with the district court. I don't think Marriott waived enforcement of this class action waiver. There's still the question of unconscionability, I think. And is there also a question of scope? Has that been preserved before us? This question of whether, assuming it's an enforceable class action waiver, it covers the tort claims in this case?
If you agree with us on the first part, this case is ready to be decided and reversed. And I say that with respect to both of the parts that Your Honor described. Unconscionability, the court said what it said about unconscionability. New York law uniformly, without exception, you'll notice that there's no case that they cite to the contrary, holds that class action waivers are not substantively unconscionable. There's also no procedural unconscionability here, which would be a second requirement that they'd have to meet. It's not like choose one and they win. They have to win both, and they win neither. As for applicability, as we point out in our opening brief, there's no dispute that this clause is applicable to the claims in this case, and the other side did not dispute that in their brief.
That's why I'm wondering if it's sort of in front of us or not, and the district court didn't allude to it.
The district court didn't speak to it, but this court has a doctrine, we talk about in our cases, where an issue is clear and it's not disputed between the parties because the other side didn't even say that it needs to go back.
I think you're misunderstanding. I'm
sorry.
suggesting it may be forfeited on appeal, like no one has argued it.
Oh, we've said throughout that it applies, and I don't know.
Right, you have.
Yeah, yes.
Right, you have preserved
We have
your
preserved it,
argument,
yes.
yes.
And.
I'll ask your
yeah,
colleagues about that.
I think it is forfeited by them and not disputed certainly in any case in this court. So,
Okay.
I see my time is dwindling, but,
I think it's over.
well then I
It's a
will,
red light, see the red light?
I do see the red light.
And we don't issue tickets on the first warning.
I appreciate that, Your Honor. If the court has no further questions, I will reserve whatever time I
Yeah,
have left
you've
for
got some
rebuttal.
rebuttal, I see.
Good. Thank you very much.
Mr. Anderson?
Thank you, and may it please the court. Devin Anderson on behalf of Accenture, addressing certification of the Rule 23C4 issue classes. Here, the district court found that there were insurmountable individualized issues.
Before we get to that, and before we move off the waiver question, you suggest in your brief, I think, maybe in a footnote, that Accenture may be able to invoke the class action waiver under an estoppel theory.
That's correct.
Can you maybe say another sentence about that for me?
Sure, Your Honor. And we argue this at the district court. Its opinion, the district court didn't address it one way or the other, but under the doctrine of equitable estoppel, where the claims that the plaintiffs are pursuing are necessarily arising out of the contracts that they have with Marriott, and their claims against Accenture flow directly from that purported contractual relationship that the plaintiffs have with Marriott, we've argued that under doctrines of equitable estoppel, that we're also entitled to invoke the benefit of the class action waiver. Now, the district court ignored that argument, didn't address it. We've preserved it, I think, both before the district
Okay.
court and before this
So
court.
it's not like you're a third-party beneficiary. This is a different.
It's a
sort of
different,
argument? Okay.
we're not arguing third-party beneficiary. There's equitable estoppel. We've
Okay.
cited some cases, I believe the dioxide
I don't wanna
case
hold you up. I
that
just wanted
goes
to make
into
sure.
that. But for purposes of the limited time that I have here, I do want to talk about the Rule 23C4 issue classes. Once the district court found, as it did here, that there were insurmountable individualized issues of injury and causation that prevented class certification of the negligence claims against Accenture, it was error for the district court to certify a class action anyway, and then to recertify it without any analysis or any effort to address the considerations this court flagged in its prior opinion. Simply put, in this case, whether you want to call it superiority or call it predominance, there is no benefit to proceeding with a class action just on the duty and breach elements of plaintiff's negligence claims. Now, I want to start by clarifying a few points that came up in plaintiff's brief. Rule 23 required plaintiffs to come forward at the class certification stage and show that they had a mechanism for establishing injury across the class using common proof. Plaintiffs made strategic decisions about which theories they would put forward from the theories that they had initially pleaded in their complaint. They selected two. One of them was the overpayment theory, but there's no dispute that that theory did not apply to my client Accenture. The only theory that was put forward by plaintiffs was this lost sales potential revenue from selling their data, which never made any sense as a matter of logic, and the district court rejected as a matter
Can I
of
just,
law.
this is just a factual question. So the district court, back when it was Judge Grimm, he sort of rejected it without prejudice because he understood that the plaintiffs had some new theories that they were developing. Whatever happened with that?
Nothing.
Okay.
That's, nothing further has happened from that.
Okay.
So there's nothing,
That's
there's.
what happens in paradise.
That's, well, we're a few circles down from paradise, I think, Judge Niemeyer, by the time we get to the issues that I'm addressing. But given that finding, that plaintiffs had no way to establish a common injury across the class, Rule 23C4 did not provide a path forward to class certification. And that's for several different reasons. For one, a shared injury is a fundamental class action requirement. I think this comes from Walmart. It comes from even earlier decisions like Schlesinger and Falcon. And this court, last time around, looked at this through the lens of superiority. And I think that's a perfectly fine way to do it. The court could also think about it from the perspective of predominance. But at some point, Rule 23C4 has to involve a careful analysis of the issues left to be decided. And in some ways, I think this court and the DC Circuit in the Harris decision, I think is also a good touch point, invokes a kind of muscular predominance-like analysis that looks at the issues that remain to be decided. And it asked the district court, in its prior opinion, to do that sort of analysis. The district court didn't do that. It recertified the classes against Accenture in a single sentence and without analysis.
Okay. I
Thank
got
you, Your Honor.
Tom. All right, we'll hear next from Mr. Zachary.
Good morning, Your Honors. May it please the court, Samuel Zakharoff for the plaintiffs below. I think the key issue in this case is obviously the waiver point. And the waiver is contained in one paragraph in two sentences in Section 1321 of the agreement. That's what this court remanded for last time for the determination of how the waiver would apply. Now, the court was asking questions about the terminology of waiver, forfeiture, and I think that the case law establishes that there are important differences. Forfeiture is the failure to raise something in a timely fashion.
And that seemed to be what Judge Grimm was concerned about, but as I understand it, is that not your argument?
Our argument is not
Okay,
the
so we all
forfeiture
agree
one
it was
primarily,
timely
Your Honor.
raised. Oh.
There is, Judge Grimm was concerned that it wasn't raised in any pleading before him for 31 months. But if you look at most of the opinion, it deals with the conduct that was undertaken in bringing this to the MDL and things of that sort.
You are not pressing today sort of a waiver by omission argument?
No, we are
Okay.
not.
Thank you.
It is in the record, Your Honor, but that's not our principal argument. Our principal argument is that this court remanded to the district court to find what were the terms that might give rise to waiver. And the district court, following the Supreme Court's instructions in Morgan v. Sundance and following the Olano case, also from the Supreme Court, an older case in the criminal context, said that when you're dealing with waiver as opposed to forfeiture, the key thing is how have you conducted yourself in the course of the litigation. And here the district court made specific findings that repeatedly Marriott acted in derogation of the conditions of 1321 on the venue point, on the choice of law point, on the
Well, let's leave those apart. I'm more interested in the notion that I think the court relied directly on is participation in MDL constitutes a waiver because.
I don't think, Your Honor, if I may, I don't think the court ever said that. That's their characterization of it.
Well, tell me what the court said then. That's
Okay,
fine.
what the court said was that their conduct in the MDL and their advocacy of the MDL is where you find the waiver. It's not being in an MDL. Obviously, an MDL is an order from the Joint Panel on Multi-District Litigation, and if litigants are ordered to go somewhere, they must go there. We don't dispute.
I'm not talking about the venue, and I'm not talking the choice of law. I'm talking about where the statutory provision said you had to proceed individually, not with a class action.
That's correct.
And
So they went to the district.
they have asserted that throughout the case in various places, in the answer and in the interrogatories, depositions, in the motion to certify. They've preserved that, it seems to me, from a notion that they deliberately intended to waive it, on any standard of waiver. The question is, by participating in the bellwether process in MDL, is that an unwitting waiver? Or what? I don't quite follow it because the statute, the clause says individually, not as a class action.
Yes, Your Honor.
And it seems to me cases that proceed on that basis can still be MDL cases and have bellwether decisions on various issues.
Yes, Your Honor. So there are many parts to your question, and let me take them in sequence. First of all, they did not consistently raise their objection to any kind of class proceeding. They didn't do anything of that sort until 2021. This litigation begins in 2018, so they were
So you say they waited 3 years?
They waited 3 years, absolutely.
I thought they raised it in their answer.
Their answer doesn't come until 2021.
Well, that's the first time you raised most offenses.
No, Your Honor, it's not. It is the first time there's a
The
pleading.
rules of procedure provide the defenses. If we had that, there's a whole list of defenses to be waived.
That is correct, Your Honor, but now we're in the definitional distinction between forfeiture and waiver. And the Supreme Court in the Olano case cited and quoted in the Morgan v. Sundance case only a couple of years ago draws the distinction between forfeiture, which is what Your Honor is describing now, which is failing to raise the matter in a timely fashion in the pleadings that are required by the rules. And we are not arguing, as I just referred to with Judge Harris's question, we are not saying that they didn't raise it in the appropriate pleadings at appropriate time. We're saying their conduct for the first 3 years of litigation was exactly what Justice
But
Kagan
if they're
described.
not required to file an answer, I'm just talking about the whole concept of the federal rules of procedure.
Yes.
They could be going on motions to dismiss, jurisdiction, venue, all the 12B6
That's correct, Your
motions
Honor.
for
We don't
years.
dispute that.
The rules do not require you to assert defenses until you get to the answer. And the list of the defenses are there, and you provide the answer. To require a defendant to put his defenses in connection with, say, a jurisdictional motion is never been required.
Your Honor, we
I
don't
think
dispute
that's
that.
a starter.
We don't dispute that. We are not here arguing that they
Their
waited.
first answer, they raised it, right?
Their first answer 3 years into the litigation,
I don't care
but
how late it was. It was their first answer under the rules.
it was their first chance where they might have forfeited it, as the Supreme Court defines that in Olano and then again in Morgan v.
How
Sundance.
can you
But
forfeit it if you don't have to raise it before?
we're not arguing that they forfeited it, Your Honor. We are
How do they
arguing.
waive it before? In other words, when
Because
you
they're
file a motion, let me hypothesize. You file a motion for a summary judgment based on a lack of personal jurisdiction, not summary judgment, 12B 1 or 3, whatever it is, for lack of personal jurisdiction. And that takes, they have discovery, they have 3 years, there's a full opinion, there's an interlocutory appeal, comes back, and then there's an answer filed in 3 years. That's when they raise the statute of limitations. Statute of limitations is waived if it's not raised.
Your Honor, that's absolutely correct. We do not dispute that. What we are saying is, and what the Supreme Court invited the inquiry, first in Olano and then in Morgan, was even if you are not required to raise it at this particular point, you may not act in derogation of that. And what the Supreme Court said in Morgan was you have litigants who frequently decide, well, I could go the arbitration route because I have an arbitration
What
clause.
conduct can you have that provides for the waiver of defenses authorized by an answer under the rules? In other words, between the complaint, service of the complaint, and the filing of the answer, what conduct can you conceive of that waives a defense that you have to raise for the first time in the answer?
Exactly the conduct that was undertaken
what conduct?
in Morgan versus Sundance.
Now, I'm
And in-
asking you not to give me a case. What conduct in this case?
What conduct in this case?
Yes.
Seeking to have cases brought in joint fashion in the bellwether process, which violates the individual clause
Of course, the MDL has said we preserve the initial notion of the litigation, and all the cases are to be treated as if they're going to be separated at the end again. We don't, the process does not constitute.
That is
waiver.
correct, but they also acknowledge that venue was proper. I know Your Honor doesn't want to get to the venue provision, but they acknowledged that venue was proper in Maryland. They acknowledged all of these various components of.
Where were the plaintiffs on all of this? I actually don't know. Did you all object to MDL and say Maryland law was improper?
No.
Well, aren't these all equitable doctrines? I guess I just don't understand. If your argument is that they, somehow repudiated the contract, well, so did you. There's no non-repudiating, non-breaching party here. I just don't get how these equitable doctrines would apply here.
What the Supreme Court said in Morgan was that a party that seeks to invoke a contractual provision that has acted in derogation of that in the course of the litigation may not subsequently invoke it against the other party. All of us.
Right, the non-repudiating, non-waiving party can invoke waiver, but you're not that party. You agreed to the MDL too. I'm not really getting this.
Absolutely. We agreed to the MDL. We agreed to the bellwether process. We agreed to venue in Maryland. We agreed to all these things. The reason, and this is what the district court was pointing to, the reason is that they hoped to get out of the case quicker and cheaper. The reason that they wanted out of this was, and that they didn't invoke 1321, was because it provided for New York law. And one of the class actions that is involved in this case is a class action under GBL 349 in New York, which has $50 liquidated damages per transgression, and they did not want to live with that. And so what they were seeking was other rulings of the district court, which is what brings this exactly into Morgan. The district court relied in part on the Hill case out of the Ninth Circuit, which is a post-Morgan case, in which the Ninth Circuit goes
You're
back.
talking about the district court, Judge Bailey, or district
Yes,
court,
Judge Bailey.
Graham?
Judge Bailey. Judge Bailey, on remand from this court, said, what is it that constitutes waiver in this particular case? That was the question put to the district court, and the district court made findings. But in part, it put the findings in the context of the Hill case, which is the Ninth Circuit going through its waiver cases in the class action context and says, if you try to get the advantage of the collective proceeding in some fashion, the consolidated proceeding, then you can't say, if it's not working out for you, I'd rather be someplace else. I'd rather invoke a different kind of procedural mechanism. And here, they sought to get joint discovery. They sought to get many of the benefits of the aggregation that comes with the MDL process. And then when, as Judge Bailey said, and this is a finding, When it didn't pan out for them, then they sought to abandon that altogether by invoking the individual treatment. They went to the MDL panel, and they filed in their response, and this is in the record, they filed in their response a statement that said one of the reasons we need an MDL is because there are multiple class actions pending, and we want consistent rulings on class certification. That's not in opposition to class certification. That's not an invocation of the prohibition, and that's a pleading filed before the JPML. That is inconsistent with their
I
invocation.
don't understand why. They want consistent certification orders, that's fine. But in their motion, in the briefing, in their first briefing on the certification, class action certification, they raised the contractual waiver.
Judge Niemeyer, I think the crux of our
That they would
disagreement.
want every court to apply the waiver similarly.
Judge, I think the crux of our disagreement is, I think Your Honor is collapsing the waiver concept into the forfeiture concept. And the court, the Supreme.
Waiver is a knowing act of waiving as opposed to omitting it.
That's correct.
Forfeiture.
That's-
But I don't think it makes a difference in this case, because in this case, they clearly did not reveal any intent to waive it. All the indicators are, in following the rules, they raised it in the class action certification, they raised it in the answer, they raised it in the answers to interrogatories, and it was
That's
covered in
all
discovery.
3 years down the road, Your Honor, and our argument is what happened in the first 3 years of the.
I don't want to speak for your colleague on the other side, but if I'm getting the timing right, I think they would say that during this part of the proceedings, they didn't know which contract you
Okay,
would be relying on, so it wasn't really.
that is a central argument they make. And the very first case that was filed in these proceedings is a case called Tapling versus Marriott, which was filed in Maryland. It was filed on November 30th, which is just after the data breach was revealed, to November 30th, 2018. And there, one of the class allegations was that it was a suit brought on behalf of those who use the SPG loyalty program. So that case, the very first one in its class allegations, ties the injury to the status of the individuals as SPG members. If one looks at the public filings of SPG from 2014, which is the year in question, one sees SPG saying to the regulatory authorities that more than 50% of its hotel sales, the nights stayed in hotels, are with SPG loyalty members. By 2023, in the regulatory filing, Marriott says the number is actually 68%. What that shows is that the loyalty program was at the heart of how they sold their rooms. That's at the heart of how they deal with their clients. And we all know it, that you check in and you get free Wi-Fi and all this. And the allegation in the Tapling case at paragraphs 78 through 80, it asserts that Marriott or SPG induced them to give their private information in exchange for becoming loyalty members. That is, that they tied the injury and their vulnerability to the fact that they were loyalty members. So this provision is their contractual relation with more than half the class, as they said initially in 2013, or 68%, as they said in 2023. So this can't be a surprise to them. And the allegations were right there from the very first class action filed.
Thank you.
This waiver issue, do we review the district court's ruling for abuse of discretion?
Yes, Your Honor. I think that there are two components to it. The first part is the district court made rulings of law as to what the standard for waiver would be. They're relying not just on Olano and Morgan v. Sundance, but also on Stern v. Marshall. And if the court thinks that it used the wrong standard for waiver and should have used the forfeiture standard, and therefore that nothing had to be said about this, it didn't matter what happened for the first 3 years, then that would be an error of law, and that's fully reviewable. But what this court did...
I'm sorry, just in describing the district court, I don't recall the district court talking about what happened during the first 3 years. The district court just said, I'm reading this entire provision, notwithstanding the severability and the no waiver clause, as being all one thing, and because they went to an MDL, that's inconsistent with this. And there was no, I understand what you're talking about, and it is possible to read our initial remand as being for an exploration. Maybe there's something we don't know about, like a weird way this was litigated that we should know about, but that's not what the district court did.
Well, the district court went through several moments in the litigation, and then they said they did an about face. And they had, by that point, abandoned 5/6 of this provision, and then that was a fact finding. And I think that if you are to reverse that fact finding,
That's a
it has
fact
to.
finding?
Yes.
It's a recitation of what he determined from the record. He does say that it has clearly waived 5/6 of the provision.
Yes, he does say
And
that
they shouldn't be
after.
permitted to cherry pick.
That's right, Your Honor. That's right, Your Honor.
But isn't that a construction of the contractual language, which would be a question of law?
Well, I think what it says is that there are parts of it that are construction of the contractual language. But if I can make one point before my time runs out on the contractual language, this court has referred to the severability of the various provisions. This contract is unusual, not just in burying the class action waiver in a section called choice of law, but it also does not have a severability provision as such. And I would direct the court's attention to the same page that was raised by my colleague here, Joint Appendix 1466. 13.19 is what purports to be the severability provision, but it's actually entitled waiver. And what it basically says is that Starwood, in its application of its program for its members, can give additional enhancements to some members without waiving the limitations as to others.
I thought the severability clause was in 1322, at the end of 1322. If any part of it is unenforceable, that
Yes.
part's deleted, the
Yes,
rest remains.
that's,
Okay.
but that's not, okay, I accept that, Your Honor. Now, let me, if I'm running out of time, if I can go back to the actual contractual language, because this is a big issue. It says, will be handled individually without any class action. And even if we can hive that off from the rest of the paragraph that it's in, there's a standard canon of contractual interpretation that says you must give meaning to every word in the contract. If it said, will be handled without any class action, that would cover the exact same conduct here. The question is, what's added by the word individually? What does the word individually do for us here? And the answer to that seems to be that it's a prohibition not just on class actions, but on aggregative procedures altogether. Otherwise,
It doesn't say that, though. It says individual, not a class action. It looks like it's defining a particular. Anyway, that's a contractual interpretation. While you're still up, I'd just like you to address briefly what the court did on our request to have superiority determined with respect to Accenture.
with regard to Accenture. So the question with regard to Accenture is, what's the standard for issue classes? And as this court noted in its opinion,
No, what did the district court do on that? We sent it back to have the district court conduct some superiority analysis.
the district court did not address superiority
I don't
as
think
such.
so, yeah.
But the district court, Judge Niemeyer, I think to be fair to the district court construed the remand to be on the waiver question, and there was no further discussion of the issue class as such. So the court is correct. It was not addressed in the
Okay.
district court's opinion.
Thank you very much.
Thank you, Your Honors.
All right, we have, I guess we have next, who's next? I guess Mr. Hellman.
And I have just I think, 4 quick points in rebuttal. Point number 1, it was the plaintiffs, including the early filed complaint plaintiffs, who moved for the MDL in this action. You can see that at JA 152. The plaintiffs moved, Marriott agreed, but the plaintiffs moved. Second point, again, I just want to stress there's a little bit of magic going on here. We're talking about actions taken years before the plaintiffs ever decided to actually base their claims, their classes, on the SPG terms. There were 31 contracts. I know we talked about the 3 years and the 31 months. They were still talking about 31 contracts 31 months into this case. So that's the lens which you have to understand what happened. As much as I think my friend would like to say it was always about this. It wasn't always about this. It was about other things because they wanted to keep their options open. Point number 3, I think I heard a lot about Morgan Sundance and the arbitration case law from the Supreme Court. The antithesis of arbitration is litigation. That's one conceptual framework. The antithesis of a class action waiver is class action certification. The time to raise a class action waiver is at class cert. If you're litigating when you're supposed to be arbitrating, assuming that the contract clearly applies, that's one set of circumstances. This is not that set of circumstances. And then the last point I'd like to make is the larger ramifications of this case. There were dozens of actions filed within 24 hours when this data incident became known, dozens of actions. The notion that because one contract might have one venue provision or one choice of law provision and another doesn't, and that to agree when the plaintiffs move for an MDL somehow waives, intentionally relinquishes a known right to oppose a class that was just a glint in the plaintiff's eyes at that point, would have been in kindergarten if you started from that point, is bad policy and not what the law requires. In fact, it's the opposite of what this court's holdings have said. If the court has no further questions, I'll give back the balance of my time.
All right, thank you.
Thank you.
And Mr. Anderson?
Your Honors, it's now common ground that the district court didn't do what it was supposed to do in terms of conducting the further superiority analysis. Please don't send this back, though, and say try again. I think this court needs to provide clear guidance that in the context of this case and given the district court's own prior findings about the lack of commonality across issues of injury and causation, a Rule 23C4 issue class simply doesn't make sense in these circumstances. The nature of these individualized issues is such that the class action is not going to meaningfully advance or create or reduce the number of trials that are going to happen in this case. These issues are not tertiary, they're not secondary. Issues of injury and causation are fundamental both to the substance of plaintiffs' claims, but also to questions of the court's jurisdiction to bind the class members that will come before it eventually at summary judgment or trial to seek adjudication of that. And for those reasons, we think that the Rule 23C4 issue classes should be reversed under principles of Rule 23. Thank you, Your Honors.
All right, we'll come down and greet counsel. There's quite a few counsels, so it'll take quite a while. And then we'll take on to the next case. All right, we're going to take a brief recess.
This honorable court will take a brief recess.
hear from you.
May it please the court, my name is Paul Sun. I represent Ikevion Johnson. Mr. Johnson was convicted of forcibly assaulting federal officers and a related 924C count. The conviction of forcibly assaulting the federal officers was plain error, as the government concedes, because the superseding indictment did not plead one of the essential elements of that charge, did not plead forcibly.
You know, it's sort of interesting. I tried to figure out what happened here because the government's usually copies the statute verbatim in their indictments, at least the U.S. attorneys. Well, that's exactly what they did. They copied the statute verbatim, but at the point where forcibly should have been, they included feloniously. So I'm wondering whether somebody sat there and did it in handwriting and wrote an F and it was mistyped. It could be a typo. It's clearly missing, or the forcibly is clearly missing, and they put in the word feloniously, but I thought I'd just share that observation.
And Your Honor, the plain error conceded by the government is the first two elements of plain error relief, that there was error and it was plain, and Mr. Johnson respectfully contends that he can show the other requirements of plain error relief, that his substantial rights were affected, and that the error seriously affected the fairness, integrity, or public reputation of the judicial proceedings. Mr. Johnson also showed.
Well, you know, that affecting the proceedings is a difficult hurdle for you in view of the fact that the instructions clearly told the jury that they had to be, it had to be done forcibly. And then the court went on and defined forcibly for the jury as a separate paragraph, and which even highlights that aspect of it. It's hard to believe that the jury would disregard such fairly extensive instructions on the word forcibly.
Your Honor, looking at the instructions as a whole, which this court says we must do, there are instructions as to that charge, which is count 4, the forcible assault charge, that do not include the reference to the word forcibly.
You're saying the instructions are inconsistent?
They're
I
inconsistent.
mean, you were saying that.
And-
Are you, but the fact that they left out an element, does that mean they didn't charge a crime?
They didn't charge this crime.
They didn't charge any crime.
Well, they didn't charge section 111A.
Well, that was the allegation.
Yes,
That was the number. They had the number in it.
yes.
Or maybe it's enough to just put the statute number in there.
Not anymore, Your Honor.
Well,
The court has made clear that you
Then-
have to
then
allege the elements.
It's your position they didn't charge a crime.
They didn't, correct.
Whether you haven't argued that that means that they violated the Fifth Amendment. It says that the defendant's entitled to be indicted.
Yes, there is a Fifth Amendment right here and a Sixth Amendment
But you don't
right.
raise that.
I did, Your Honor. I argued that the right that's violated here
And his
Fifth and Sixth Amendment rights.
You weren't the trial lawyer.
I was not.
I know. And his lawyer in the district court didn't move to dismiss the indictment.
Did not,
And the indictment was one time superseded.
yes,
And they corrected a couple clerical errors,
right,
but they didn't fix this one.
right.
So he was actually being tried on a superseding indictment
Right,
that didn't fix the failure to charge a crime in count 4.
right, count 4.
And then they had a trial on the charge that wasn't a crime. It didn't charge the elements of the offense. But his own lawyer offered an instruction that fixed it. And the prosecutor offered an instruction that fixed it. Both lawyers offered instructions that fixed it. Right?
Both lawyers offered instructions that included the word forcibly. as part
Included
of
the word
instructions.
forcibly. You
Yes.
don't have to say it fixed it. They included the word that was left out.
Yes,
Does that mean that the indictment was amended at the trial?
couldn't do that, Your Honor, no.
We've said you can't amend the indictment.
Supreme Court's actually had cases where they omitted elements of the offense I'm trying to think of which one it was, but, and the court says you conduct a plain error analysis.
It
Well,
is,
the Cotton case,
Cotton, yeah, I guess it is.
the Cotton case, the Supreme Court said you can fix it.
It
I mean,
is-
you can, if the evidence is overwhelming and uncontroverted.
right.
But I'm just bothered by the fact that it comes up here like this.
Well,
I mean,
and again,
There's
that's,
no question that it's sloppy practice. And it's not just on the prosecutor's part, it's on the defense lawyer's part.
both sides.
I mean, the prosecutor's admitting error, admitting plain error. And they shouldn't have to do that. Somebody can read the statute. And the defense lawyer should have made a motion to dismiss. If they
Right.
weren't going to, or you should have told them about it. Somebody make a phone call. They left out this, I don't know what to do, but it's a mess. And maybe in the Cotton case says that you can fix it. Supreme Court of the United States.
We're in plain error
So
territory.
does that make your argument faulty? Or can we still do something under prong 4?
Yes. I have to show.
Or can you reach prong 4 without deciding prong 3 of
Well,
Milano?
You do have to, Mr. Johnson has the burden to show all 4 requirements.
That's right.
But I want to circle back just briefly to Judge Niemeyer's comment about the jury instructions and highlight one thing. When the trial court instructed the jury, it talked about the verdict form and said, I'm going to attach the superseding indictment to the verdict form. So there are a lot of instructions in there. There's some of them that talk about forcibly, but when the jury went back to the jury room, because there's nothing in the record that shows that the instructions went back to the jury room. What did go back is the verdict form, and the verdict form has attached to it the superseding indictment. So when the jury is deciding, are we going to convict, find guilty or not guilty, what's right there is the defective indictment. And that's part of the instructions, and we think makes a compelling argument why.
A jury might, well, in this kind of, depending on the burden, read the word feloniously to require forcibly, because they were told what had to be, that forcibly had to apply. And the word feloniously is in there.
It is.
And that wasn't defined for them.
But I do have to show all of the elements to get plain error relief. And the third element is effect on substantial rights. And the right here, again, at issue, Judge King, is the Fifth Amendment and Sixth Amendment rights to have the grand jury charge all of the elements. But what the Supreme Court has said is,
But it doesn't have to be prejudicial?
yes, that's what the Supreme Court says, that Mr. Johnson would have to show that but for the error, there's a reasonable probability that the jury would have come to a different conclusion. In other words, found him not guilty.
Well, let me just move on to a little bigger picture, and you can tell me it's totally irrelevant, but the jury was presented with evidence that the force used against the officers was the shooting of a gun. And the defense was that, well, he didn't aim or didn't hit them or didn't really threaten them. But the fact is, the charge was that they had to resolve that the defendant used a gun against the officers.
Yes.
And your argument, of course, is whether the gun was sufficiently directed at the officers. But that's what they're resolving. Now, is there any doubt that the use of a gun would be forcibly?
Well, if you're holding the gun,
No, I'm assuming that they had to resolve that the gun was satisfied the assault of the officers.
That it
So,
was.
but the question is forcibly is an adverb as how that he used it. My question is, wouldn't the assault have to be forcibly if they found he used a gun against them? There was no other, this is not a case where he offered to hit them or slug them or he's speaking bad words against them. He used a gun.
right.
And if the jury were to find that the gun was indeed directed at the officers and assaulted the officers, then the fact that a gun was being used would necessarily be forcefully, wouldn't it?
Well, I think it has to be, and Your Honor said this, directed at the officers.
No, I know, but that doesn't solve the one
They were
forcibly.
firing at the car, weren't they?
They were in the car.
They were in a car.
Yeah.
They were firing the car, and they didn't know they were officers, I thought, under the
No,
evidence.
They did not.
But they were officers,
They
they're
did not.
FBI agents, and they were going through the stoplight or something.
Well, and.
But they were firing at whoever, they were mad at whoever it was they thought was in the car.
Well, the evidence is.
They had the bad intent, but they didn't.
But my whole point, that goes to the sufficiency of the evidence argument you have. But my point is on the word forcibly. The fact that the instrument in this case was a gun seems to me it's not overwhelming, it's conclusive that if you used a gun in the form of an assault, then it's forcibly.
If you use the gun in the
Yeah,
assault.
right.
Let me
That's
put it
right.
this way, could any reasonable jury conclude, yes, your client assaulted the FBI agents with a gun, but it was not forcible?
I don't think in this case, Your Honor.
Right, you couldn't.
Not in
Okay.
this case, Your Honor. But the evidence is, well, there's no,
That's on the sufficiency.
I don't think, I think it covers
Your
both, Your
argument on
Honor.
the sufficiency is that Johnson didn't know that these were officers. He thought it was a rival gang, and he fired the shot and missed, but fired the shot at that car. There was nothing else there, according to the evidence. So he was firing at that car, thinking it was a rival gang. Isn't that right, or group?
Well, I'll vary slightly, Your Honor, in that there isn't evidence, there is not evidence that the shots were at the car. Agent Miles says, I didn't see gunfire at all. I just heard it. I just heard it. I didn't see gunfire at all. I couldn't see in the car. There were 3 witnesses. There were 6 people in the car altogether, but 3 witnesses testified. 2 of them, Ackland, who was the driver, says, well, they all say Johnson was the shooter. They're consistent in that. Ackland, the driver, says, the gun was by my head, so out the window in the back. Ms. Little, who's next to Mr. Johnson, says, I put my head down. I didn't see anything. Ms. Carr is the only one who says Johnson shot at the vehicle behind us. And that's at JA 96, and she repeats behind us at JA 108.
Well, it was behind him
No,
earlier.
it wasn't. It never was.
I thought it was following him
The
at one point.
no.
Okay.
According to Agent Miles, the Black Explorer, the full facts are they're in this cul-de-sac area trying to conduct surveillance. And they leave that and they turn right on what's Old River Road, and they turn back, this is Agent Miles and Task Force Officer McKnight, turn back around and head the other way, and they see this Black Explorer, Agent Miles says, coming up rapidly behind them. And Agent Miles decides to try to determine, are they following us? So off of Old Airport Road, he takes a right, Old River Road, I'm sorry. Off of Old River Road, he takes a right on Airport Road. Explorer comes behind him. He takes a left on Perkins. The Explorer keeps going. Agent Miles does a U-turn on Perkins, comes back out because he says we want to get behind the Explorer because we want to check the license plate. We want to see who this is. So he comes back out on Perkins out to Airport Road and turns left. That's the direction that he saw the Explorer going. But in his rearview mirror, so behind him, he sees the Explorer come up to the intersection. So at all times, the Explorer is behind the unmarked vehicle that has Agent Miles and Task Force Officer McKnight. So
But there was no car behind the car Johnson was in, was there?
Agent Miles says the only cars on the road that he saw were his car, the one he's driving. No other cars besides the Black Explorer that Ackland is driving and that Mr. Johnson is. He says that's the only car we see.
So then if you hear shots, they're probably aimed at your car. There's no one else to be aiming at, right?
If you're aiming.
I mean, the question isn't really whether someone tried to shoot the officers. It's whether the officers were in reasonable apprehension when they heard gunshots and radioed in, were under fire, and put on their body armor. So what's the best case that, like, they were just being way overcautious?
Well, I think, may I continue, Your Honor? To finish
Yeah,
the.
why don't you take one more minute?
Okay. So the best case is, Agent Miles didn't see anybody shooting and task force officer shooting at them.
I mean, in this day and age, if I hear gunshots, whether I see someone aiming at me or not, I feel that I am in reasonable apprehension that someone is shooting and that I might get hit.
My best case
I mean, our
scenario,
kids are
Judge
taught
Harris,
that in school. It's wild.
my best case is Agent Miles didn't see anyone shooting. They did go after, he drives after the car. He doesn't shoot at it. Now he says, that was not policy. I didn't
I
shoot
mean,
at
yeah,
it.
we don't really want to, like, fault police officers for not doing these things that have been these high-speed car chases with firing at people, which most police forces have said is unduly dangerous to people.
But those are the facts that I would highlight, Judge Harris. Thank you.
Thank you. Ms. Englander.
How does this indictment get so messed up?
Thank you, Your Honor. Kate Englander for the United States. Your Honor, no question that there was an error in the indictment. As best we can tell, there was a form template that was incorrect. It has now been corrected, but that's what was used.
That's even worse than what I anticipated. I thought forcibly and feloniously could have been handwritten by somebody and just misread. But if you had a template, that's even sloppier, I guess, but you fixed it.
There's no excuse for it, Your Honor. It was an error that was plain, but
Hopefully, you got somebody reviewing indictments. I mean, that's.
there's no
I
question.
know this Cotton case seems to settle this, maybe, but this seems like it's a structural flaw to me. You ought to have to be indicted to be tried in the United States of America.
Your Honor, this case, so this issue was raised for the first.
And this indictment was not an indictment.
Well, it wasn't an indictment. It had an error in it. There's no question about that. But
It didn't, an indictment alleges the elements of the offense. That's rule number one of what an indictment is. And it's in the Fifth Amendment of the Constitution.
that's absolutely true, Your Honor. There is no evidence, however, in this
And-
case
and
that.
we expect the government to do things right. And it's plain English. It's not hard to do. It's a simple indictment. It's not a complicated one. It's a simple statute.
There's no indication here that the error in the indictment impacted the defendant's substantial rights.
But then you had a superseding indictment that fixed something else, and nobody read the indictment or the statute at that point.
Fortunately, in this case, Your Honor, the jury was properly instructed that forcibly was a necessary.
And then as Mr. Sun points out, the flawed indictment was given to the jury.
Yes, but
This, and forcibly was, or whatever, the one, the forcibly was what was left out, feloniously was in there.
but the
Knowingly and feloniously or something.
The court repeatedly instructed the jury that they had to find that the defendant acted forcibly in order to convict him beyond a reasonable doubt. They did that. The court used the word forcibly 8 times. It said forcibly is an element. It defined the element forcibly. And more importantly, Your Honor, there is no question in this case that the defendant acted forcibly. That was not contested.
I agree with that. The evidence, that's right. But the defendant was entitled to be indicted under the Constitution. And the United States Attorney is supposed to sign the indictment So does the foreman of the grand jury. And the foreman of the grand jury relies on the United States attorney to get it right. And it's not difficult.
I agree, Your Honor. It was absolutely a mistake. It should
And you,
not.
and you confess error, but only as to the first two prongs.
That's right, because the defendant was not prejudiced by the error here. The jury was properly instructed, and the defendant also, there's evidence the defendant had actual
the-
knowledge of the elements because he submitted jury instructions that included the element. The government,
You're arguing what I used to call, or I still call, the clearly guilty rule. Right? He's clearly guilty, so he doesn't need to be indicted properly. He doesn't need to be tried fairly. Well, the system means something. We're supposed to do it right. It needs to look right. And that's what that fourth element of harmless error is about. What's it say? What's the fourth element of harmless error?
seriously affect the fairness, integrity, or public reputation of the
The
judicial
public
proceedings.
reputation of the proceedings is adversely impacted when you try somebody without indicting them first.
Your Honor, I'd point the court to the Supreme Court's case, United States versus Greer. That was the
these
case where.
guys, they're pretty clearly guilty, and they deserve some time in jail, and they got it. But the public reputation of the proceedings is that they be fair.
And, but
If
the
these guys are gonna be treated unfairly, the next case is not gonna be as clear.
the proceedings here
If you
were.
get away with it in this case, you argue, well, we don't have to worry about the indictment in the real close case.
Your Honor, the government is
Somebody
certainly.
else is gonna be affected. The reputation of the proceedings is gonna be affected. The reputation of the lawyers are affected. And it wasn't just your side of the lawyer fence, it was the court-appointed lawyer who didn't know enough to make a motion to dismiss, to read the statute and read the indictment and know that an element was left out. And you could make a motion to dismiss, it'd be one sentence long, and then the U.S. attorney would have known enough at that point to go back to the grand jury and put the right words in the indictment, put the elements in the indictment, and it had a good indictment. And he would have done something good for his client and for the system.
I agree, Your Honor, and that
We
was.
wouldn't have this.
Agreed. That was not done here. So, but everyone, the point stands that everyone understood what the necessary elements were that had to be proved at trial.
They understand them, you understand them because they were supposed to be written down. They understand them because they're supposed to be written down in the indictment. That's what the Fifth Amendment says.
So I'd point the court to United States versus Greer, which is a case where the government failed to allege an essential element.
What
And
they've been gotten to is Greer and Greer came to this court. I know these cases.
but in Greer,
I understand them.
in
But-
Greer,
But the fourth prong of the harmless error doctrine is what you said it was. The public reputation of the proceedings would be adversely impacted.
Right,
If
but
they're
we-
sufficiently adversely impacted, you don't satisfy harmless error.
but this is
And
not
if
harmless
you-
error.
and
So
if it's plain error. You don't satisfy plain error. You understood what I mean. It's like me saying, you saying that you don't have to put the words in the indictment.
Your
I
Honor,
don't have to get them in my question as much, or my remark.
Your Honor, I think a couple of points. So first of all, in Greer, the government didn't allege one of the essential elements, and the jury was not instructed that they needed to find that essential element. And the Supreme
And
Court
right,
still.
and his own lawyer fixed it for him. Rather than objecting to your instruction, he gave him an instruction that fixed it for you.
Well, Your Honor, certainly
mean,
if he had objected at any point
to
before
his credit-
trial, the government would have sought a superseding indictment to fix the error. That's why we're on plain error
They
review
were
as opposed
instructed
to.
right, but then they were given the wrong indictment, which is inconsistent, as Mr. Sun says. The things are inconsistent. He gave him an instruction, but then gave him an indictment that was inconsistent with the instruction.
I don't think that the instructions were inconsistent. In the portion of the instructions where the judge tells the jury, here
Well,
are the elements.
instructions was correct, and the indictment was wrong.
That's right.
They were inconsistent, and the indictment went to the jury room was with the verdict form.
Even if the
That's what
jury,
the record shows, anyway.
that's right, and that is what the record shows. But
Did you
even,
try the case?
I did not, Your Honor. Even if the jury hadn't been properly instructed here, and they were properly instructed, the defense still has not shown any reason to think that the forcibly element wouldn't have been met. So the evidence on forcibly is
That's what I said.
overwhelming.
You're arguing clearly guilty rule.
I'm arguing that he wasn't prejudiced by the
He's
error.
clearly guilty.
The evidence was that the defendant shot a gun 8 times on a public city street in Greenville, North Carolina.
Well, does the public reputation of the proceedings require that he be prejudiced? The fourth prong, that part of the fourth prong of the plain error standard?
It does, Your Honor.
Does that require prejudice?
It does, because the court cited Cotton, if the evidence is overwhelming and
I'm talking about the fourth prong alone.
I think yes.
Wasn't Cotton decided on the fourth prong?
It was, Your
In the
Honor.
Supreme Court, they skipped over 3, went right to 4, said the evidence is overwhelming and uncontroverted, so you haven't met prong 4.
That's exactly right. So our position is that as to both prongs 3 and prong 4, the court should consider the fact that the evidence was overwhelming. But I think even before you get there, it's important to recognize that the defendant did have actual knowledge of what the correct elements were. The jury was properly instructed here. And so, again, conceding completely that this was an error on the
There
part.
might even be an argument that the word feloniously in the indictment would not be read by the jury to be inconsistent with forcibly. The court could have been explaining that feloniously meant forcibly because it required forcibly as an element of the defense when instructing the jury. I don't want to justify the use of feloniously, but I'm not sure a jury would have perceived feloniously to have been inconsistent. It just needed further definition, and the court gave that. But maybe they did, is what Judge King's pointed out.
I agree, and I also will just point out that the indictment did talk about a firearm. So in count 3, the defendant is charged with discharging a firearm in connection with a crime of violence. So there was indications there that forcible conduct was part of what the government was charging. But again, it was a mistake to not have the word forcibly in there. There's no question about that. Unless the court has further questions on this, I'll move on to the sufficiency of the evidence argument. So the defendant has not shown that no rational trier of fact could have found him guilty. There was substantial evidence that Johnson shot at the officers and that his actions were perceived by them, created in them a reasonable apprehension of immediate bodily harm. And I just want to touch on a few of the facts that I think are important here, because I think the reply brief frames this as the officers heard popping noises and there was some sort of confusion. That's really not consistent with what the evidence was at trial. So at trial, Special Agent Mines testified that their vehicle was being followed, that essentially another vehicle came up on them very quickly. They made some evasive maneuvers to try to determine if they were being followed, and that he did say he heard popping noises, but then he said they sounded like gunfire. That's at 54 to 55 of the record. He immediately told his partner, Officer McKnight, we're being shot at. Officer Mines testified that McKnight agreed that they were being shot at, and they radioed that they were taking fire. And he even said in his testimony at 57 to 58, to me it sounded like small arm semi-automatic gunfire, and that is consistent with the gun that was found in the vehicle. I think the fact that the officers followed the car is evidence that they perceived that they perceived danger. Other, officers, first responders are trained to go towards the danger. So the fact that they followed the car is evidence that they didn't write this off as sort of a nothing thing or weren't at all confused as to what was happening. They perceived themselves to be in danger. And it's also not factually true that there was no evidence that Johnson was shooting at the car. So the testimony from the folks inside the car was that they were targeting this white vehicle, that they were following it. Somebody believed that a rival gang member was inside the vehicle.
They didn't know they were federal officers, though.
Correct, they did not. But that they were following that vehicle, they were targeting that vehicle, and one of those people testified that shots were fired at the white vehicle. I know there's some confusion in the record about whether the vehicle was behind or in front. I would just point out to the court, the testimony was that the firing was at the vehicle, it would be a credibility determination for the jury, and certainly as to whether that testimony was credible. And certainly there's plenty here in the record for the jury to have found that the officers had a reasonable apprehension of bodily harm. And if there are no further questions on that, I'll move quickly to the sentencing issue, which I'd like to address. The district court did not abuse its discretion in sentencing Johnson to an upward variant sentence.
Just to clarify, so you are not defending the sentence as a departure? In your view, this was a variance, and that's the ground on which you're defending it?
That's correct, Your
Okay.
Honor. So the statement of reasons indicates that it's a variance. That's at 344 in the record. The court ultimately talks about departure and variance, but ultimately does say that he's varying. That's at 338 in the record. And at 341, he says that it was based on the 3553A factor. So I think it's pretty clear from the sum total of the record that it was a variance.
So
not-
what was he talking about with the step-down process? Like,
So-
did he use that to figure out the variance?
I think that the court was trying to anchor his ultimate decision in some type of a guidelines band, and that he was making an effort to find that band the same way you would if you were doing a departure, but I don't think it was inappropriate here to do it as as a variance. And the court did explain, I think, why it was doing it pretty clearly. The court talked extensively about the danger of the conduct the defendant had engaged in, talked about the fact that it was basically luck that no one had been hurt or killed. The sentencing court was also the trial court, so it had heard all that testimony. It heard pretty extensive victim impact statements. And it also made, cited certain paragraphs of the PSR.
Yeah, I had a question about that. So, right, the district court incorporates paragraph 18, which has a ton of stuff in it. And the district court doesn't say, like, for what or why he found it significant. I'm not sure I've run across that before. What kind of weight am I supposed to give that? I literally don't know which of the many things in paragraph 18 the district court was talking about.
Well, I think paragraph 18 deals with some, what a confidential witness said the defendant was doing while he was in custody pre-trial, and I assume post-trial, but pre-sentencing as well. I think that conduct concerned the court, right? He talked about the defendant trying to join gangs while he was in prison, and also making admissions to that person about certain offense conduct that was proved at trial. And the court was relying on that.
Yeah, okay. So in your view, I should read that incorporation as saying each part of paragraph 18 bothers me for reasons that should be self-evident.
I think that the court said a lot of things about what it was concerned with here.
I guess if you took out the incorporation of paragraph 18, would that be a problem for your argument?
No, Your Honor, because I think, again, most of what the court is talking about is the conduct, the offense conduct being really concerning. And again, this is looking at a sentencing for, obviously there's the 924C, which is 10 years consecutive, but then there's sentencing for the assault. And the guideline range on that is 30 to 37 months. This is obviously.
This is a question that I've had so many times, sorry, since you still have 3 minutes. When we're trying to measure sort of the degree of a variance, are we supposed to look at the total sentence, adding the 120 months, or do we just look at the assault sentence? Because you come up with a different delta. What's the right approach? I've always wondered that.
Sure, Your Honor. I'm not sure I
Okay.
frankly know the answer to that. I think that you could look at the whole sentence and say, certainly I think that's what the court was doing, was looking at the whole sentence. But I do think it's worth noting that this is on the very, very, above the guidelines range type of assault conduct, because this is not, spitting at an officer, it's not punching an officer. This is, obviously, ultimately the government did not proceed with any kind of attempted murder, but this was a shooting. And again, they didn't know that they were officers, but this was a shooting indiscriminately at another vehicle. So it's at the very high end of what could be considered, I think, assault
I
conduct.
think the judge, if you're reading between the lines a little bit, maybe not even explicitly, I think the judge was very concerned about the nature of this conduct, in the sense that if somebody had been hit and killed, it would have been a federal officer. And we're talking about a hugely problematic type of crime in the judge's mind. And it was just because he was a bad shot that we didn't have more consequence. And I think the court thought this crime therefore was serious on that basis. That's what I took from it.
That's absolutely right, and that's exactly what the court said. He said when he fired those 8 shots at the car, that 2 FBI agents were in, he could have killed them, and it was just the result of lucky physics, that the bullet's not hitting the target. But he did point out, I think, we could have had 2 dead FBI agents here. What would the appropriate punishment be then? And it'd be very, very high, obviously. I think defense counsel's response to that would be it'd be life or the death penalty. So that was certainly went into the court's consideration of what an appropriate sentence was here. And I just point, I know that the court did engage in the sort of stair-stepping that would be more consistent with the departure, but the court said at the end, he believed that the range that he ultimately landed on more appropriately fits the seriousness of the offense, the need for punishment equivalent to the danger, and the attack on law enforcement institutions. I think that's a more than sufficient explanation for why the court did what it did there. And I did want to just briefly address, I know my colleague in their brief addressed the fact that there were some disputed portions of the PSR that were relied on. I just want the court to understand that they weren't actually truly disputed in any kind of factual sense. I know we cite United States versus Terry in our brief, but I want to point the court to 306 of the record, which is the objection. The objection says the defendant respectfully objects to the statements contained in the noted paragraphs as the statements relate and pertain to all of the appellate rights afforded to him should he choose to employ those rights upon entry of judgment in the matter. That didn't give the court anything to go on in terms of actual factual dispute as to those paragraphs. So we would submit it was totally appropriate for the court to rely on those. And I see my time is almost up. If there are no further questions, I'll sit
All
down.
right, thank you, Ms. Miller. Mr. Sun, you have some rebuttal?
May it please the court. I will pick up again on the absence of evidence that Johnson or anybody else was shooting at the vehicle. The only testimony of anyone, it's not Agent Miles, it's not Ackland, it's not Little, it's only Carr, and she says he was shooting at the car behind us, and as we pointed out, we cited the U.S. v. Patterson case, it usually is a credibility determination, but not when it's physically impossible. The police vehicle was never behind the Explorer. It's physically impossible to be shooting behind. That's what she testified to twice, 96 and 108. And so there's no credible evidence that Mr. Johnson or anyone else shot at
Who is he
the vehicle.
shooting at?
He was shooting.
Pardon me?
He was shooting.
I know, who is he shooting at?
There's no evidence he was shooting at anyone.
Well, it's not okay just to shoot up. I mean, I guess I don't understand. If you shoot up in the air on a city street and somebody hears it, why aren't they in reasonable apprehension of bodily harm?
And Judge Harris, I did the best I could to give you what I thought was my best case scenario, but I did forget one detail. And actually, counsel mentioned this. There were substantial victim allocutions at sentencing by both Agent Miles and Task Force Officer McKnight, who said, I was fearful, I was in fear. No such testimony at trial. The government didn't elicit any of that from Agent Miles, so the jury didn't hear any of that. Now, it's a reasonableness test, and I concede that. That's what the statute says, reasonable apprehension. But when the government has the burden of proof and doesn't put on the testimony of one of the two, Task Force Officer McKnight did not testify, only Agent Miles testified, FBI Agent Miles.
But it came in that they put on the body armor, right?
After they tried, yes, Your Honor, they did. After they tried to chase down the vehicle, decided that they couldn't, they lost it, then they stopped and put on the body armor. They did. May I also address the actual knowledge question to the extent that goes to substantial rights, and I think that's the government's argument. And we cited the Hooker case in our brief. Actual knowledge does not determine that rights are violated. Hooker is not a plain error case. It's a motion to dismiss because the indictment is defective. But obviously in that case, the defendant knows that the defect exists in the indictment. And Hooker doesn't say actual knowledge has anything to do to undermine the right that's at issue here, which is the Fifth Amendment right. It is the case, Judge Harris, that the court, in fashioning its sentence, can take into account on the non-mandatory minimum part the fact that the court is imposing a mandatory minimum on a related count. I'm embarrassed to say I can't remember the name of the case. It's a Supreme Court case, and actually I cite it all the time when I'm arguing for a lower sentence in the district court, because when there's a mandatory minimum sentence, I want the district judge to know or think about, look, you're already giving 5 years or 10 years or whatever it is. That ought to be a reason to consider a lesser sentence. So it is certainly the case that it's the total package that the court properly considers, and that includes, in this case, a mandatory minimum
That makes the degree of
sentence.
the variance less in this case. If you just look at the assault, it's a big variance. If you look at the total package, it's not that much of a variance.
It's more than, on just the assault, it's more than double the top of what the court finds is an enhanced, because the court adds the instruction enhancement, an enhanced guideline range. Respectfully, Your Honors, convicting Mr. Johnson of forcibly assaulting federal officers when forcibly, that element was not pleaded in the indictment, is plain error. Mr. Johnson respectfully contends that he has shown the other requirements for plain error relief, that his substantial rights were affected, and that the fairness, integrity, or public reputation was substantially affected. And there is overlap when you're talking about the weight of the government's evidence, because unless, it's only the case when the evidence is overwhelming and essentially uncontroverted.
Yeah, but
that-
see, the evidence we're focusing on the absent element, which is forcibly, is whether the gun is an element of force. And it seems to me on that, it's almost conclusive. Whether the force was used against a federal officer is the other question, but that would not have been affected by an indictment that had forcibly or didn't have forcibly. The forcibly clause adds the element of use of force, and it seems to me on that issue, we had the evidence that the gun was used.
Under the statute, the deadly or dangerous weapon part, which allows for an enhanced statutory maximum, has to be used in the commission of the offense. And
Well, I'm talking about the indictment. It's an adverb modifying the assault. In other words, you commit the assault forcibly. And the question is, it said feloniously, and the judge says forcibly, but it was not in the indictment. But my point is, when you're looking at the evidence with relation to that, the question is, there's no question that force was used and the jury's instructed on force. In other words, they could not have ever found non-force with the use of a gun. Now, they could have found that the force was not used against the officers, but that's another issue. But anyway, I understand your point.
thank you, Your Honor.
You're court appointed, are you?
I am, Your Honor.
I want to acknowledge that service. It's so important, as you know, and we value it very much, and you did a nice job for your
Thank you
client.
very much.
Yeah, we'll come down and greet counsel. Good. Okay. We'll come down and greet counsel and proceed on to the last case.
Thank you, Your Honor.
The next case we'll hear this morning is Bills versus Virginia Department of Education. And Ms. Fuller, whenever you're ready, we'll hear from you.
What an honor to be here. May it please the court. This case is a case about parents trying to bring the rights of their disabled children under the IDEA and the 504 Rehabilitation Act. When their children were placed in virtual learning, they were not permitted their rights under IDEA and the 504 Act to receive their services and accommodations as written in the IEP. Essentially, the IEP is a legal document, which is a contract.
Before we get into legal, let me just get the structure, if I understand it correctly. We had COVID probably blooming in February of 2020. And in March of 2020, they closed the schools and send the kids home because of the enormous risk from COVID. I mean, it was actually risking lives and killing people regularly, and put all the students on virtual learning, right?
Yes, Your Honor.
And they did not segregate out children with disabilities or anything. They treated them all the same.
Yes, Your Honor.
Sending them home, is that right?
Yes, Your Honor. So,
And your argument is basically that the effect of that would be different for disabled children because of the nature of the learning process.
yes, Your Honor, that although the situation of all students was the same with respect to virtual learning, and we do not dispute that it was appropriate for them to be placed in virtual learning. What our argument is that there was a disparate impact on the children.
I'm sorry, I thought, but aren't you seeking prospective relief? I thought you wanted an injunction and declaratory judgment saying, if this ever happens again, don't do
Absolutely.
this. So,
It's not a matter of whether the children can be placed in a virtual setting. We would argue that that is a change in placement where that impacts the provision of their services and accommodations under the IEP.
so what kind of an injunction do you want?
We would argue that once you change a student's placement, that there's an invocation of stay put rights under IDEA, where they would be entitled to receive the services legally that they should be receiving in person, so that you can't just say, just because we have an IEP in place for a virtual placement, that you are therefore getting the same services as legally required through the IEP. Actually, the OCR, the Office of Civil Rights.
I'm sorry, thank you. Let me just, so your brief says this is a case seeking declaratory and injunctive relief to enjoin them from denying these rights. And I guess my question is, why is that a justiciable claim now that everyone is back in school?
We would argue that this is not a moot issue.
Well, it seems like it's both moot and you don't have standing, because I don't understand what ongoing, can you explain to me why there is standing for prospective relief in this case?
Yes, Judge Harris. In League of Women Voters versus SC Andino, which was from this Fourth Circuit, the court said that voluntary secession doesn't apply if there's no guarantee that it will not recur. So
That's a mootness case, and I guess I wanted to start with standing. What's your concrete current injury?
the current injury is that whenever the school district decides that there can be a virtual placement.
That's
or
not current, that's something that might happen in the future? And
It is
has to
still
be-
recurring, because what happens is due to staffing shortages or due to a student illness where there's, perhaps they go in homebound or home-based instruction.
Yeah, but that's not the facts of this case. Basically, you're grounding your facts of this case on the order to close schools in light of the pandemic, and that they were sent home on virtual. Now they're all back, and the question now is, what is the basis for forward-looking relief? I mean, you have to assume there's going to be another pandemic, and it seems to me that's pretty speculative to justify an injunction.
I would agree with that point about another pandemic. However, this comes up every day. If there's
It
a,
doesn't come like, you don't
That's
allege
not
it's
your-
coming up
Right, that's
every
not
day.
your claim, that
Yeah.
if one day the school's shut down because there's a broken pipe, that's not your claim.
no, it's, we say per honig that when there's a change in placement of more than 10 days, where they change the, let me go back first to AW, XREL, Wilson versus
No,
Fairfax
let's
School
stick
Board.
with your complaint first.
Okay.
Your complaint is based on closing the schools by reason of COVID.
Yes.
And you're, on the basis of those facts, you're seeking an injunction.
Yes.
And the question I have is, don't we have to assume that we're going to have another pandemic such as to provide need for an injunction at this time?
Respectfully, Judge Niemeyer, I would say that this is something that comes up every day. If there's a staffing shortage, they're provided virtual
You
services.
mean what you've alleged in the complaint comes up every day?
Yes, Your Honor.
But what you allege in, well, I don't see that. You allege in the complaint that the COVID is the reason they closed. That's why I wanted to go over the facts initially with you. We can't just seek advisory opinions or try to correct societal conduct in a general sense. We have to have real cases, we have to have real injury, and we have to have injunction, we have to have projected, we have to have injury projected in the, that's not speculative.
I absolutely agree that this is not speculative, Your Honor, that a change in placement, ultimately this comes to a change in placement, which
No,
is,
that's too general, that's way too general.
If you want to bring a complaint, if you want to bring a case about a staffing shortage that allegedly deprived your clients of the right to their placement, bring that case, but that's not this one.
well, that's why I was bringing up AW, XREL, Wilson, because that's saying that location, a change in location does not necessarily determine the change in placement. It is where the student is still receiving their services determines a change in placement. And so
Today, they're receiving them in, as they were before the pandemic, right?
I cannot speak
Well, if
to
you
that
cannot
because
say
I
it,
do
then-
not know if the school district is providing virtual services. The
So
child,
my point is the pandemic sanction is over. The students have returned to class, right?
that does not make it moot.
I'm
It
not
does-
talking about mood, I'm talking about why we need an injunction.
Because the student, the school districts and the VEDO can determine that they're going to go to virtual services, virtual education whenever they want. So this is something that's going to impact students, indefinitely, but also these
So
students,
you want us to legislate essentially?
no, I would,
Let's say anytime that they need to close school because of a gun violence or a broken pipe or toxic food in the kitchen, they would have to do something. We would then have to say they have to do something in light of that. And the question, we'd have to determine how long is that? Is it for a day? Is it for 2 days? I mean, this is nothing about what your complaint is about.
ultimately, the complaint is asking the court to determine that when there is a change in placement, that the services that are guaranteed under their IEPs and
complaint-
ideas should be
the complaint
provided as
wants-
written.
The complaint wants you to, what you want reinstated, wants to declare the defendants to be racketeers.
We will concede that, Your Honor, that
Well,
we
you
will
got two
concede that
counts.
argument
You got
is.
2 counts under racketeering under the RICO Act. You want punitive damages, attorney's fees, assignment of a RICO special monitor to audit the
At the
school
time-
systems, and you allege, you pick out 6 of the main school systems in Virginia and throw them in here as defendants.
I believe at the time that this was filed, there was concern about the use of the special
Time
education
of the
funds, but
which?
we are
At what
conceding that,
time?
we're conceding on RICO. We're not really
At what
pursuing
time-
that claim.
At what point in time did you say?
Initially, when we filed the complaint, there was
You ever heard of
concern.
Rule 11?
You probably know it much better than I do, sir.
But you say you're conceding on the RICO counts,
Ye-
or 2
yes,
counts?
yes.
Counts 9 and 10, well, you got 8 counts ahead of that.
Yes,
Just a minute, on the RICO counts, are you withdrawing those counts?
yes.
Why haven't you done so?
That is something we can pursue.
You've had how many, 3 years or more? You didn't tell that Judge Moon.
Actually, you were told by a judge in New York that those claims reeked of bad faith and contrivance. And it seemed to me that if you can then file another lawsuit, or you've filed multiple lawsuits on this very same thesis, that courts should start sanctioning that type of thing.
Ultimately, we're concerned about the ability of the disabled students to receive their services and
So
accommodations.
RICO is the approach you think is appropriate?
Your Honor, today I'm here to defend disabled students and not so much RICO.
You're here to try to get this complaint reinstated. And the complaint alleges, as I said, and I started at the bottom, 9 and 10, RICO charges, racketeers. You're declaring the school boards a bunch of racketeers.
I believe that if they were receiving federal
But you
funds
got
to
10
provide services that they
10
did not
alleged
provide.
causes of
However,
action.
I do concede that we did not meet the requirements under the statute. But I think the concern is just that the students did not receive the services that they were getting
Can I
federal
just ask,
funds
is there
for.
any-
Well, what
Anything
about the lawyers that had to defend this to get to this stage? That's what the Rule 11's about.
I actually don't know those lawyers, and I'm here today
Lawyers
just.
are right there, and they've spent money defending this case below and above, and face these charges, which are extravagant. I guess you must agree on that at this point, but I don't know how many judges have told you. How many of these cases have you filed around the country?
I believe that initially the concern was.
No, how many cases have you
I
filed?
can't answer that with.
An estimate.
More than a half dozen?
I am newer to this firm than when this was initially filed, so I can't answer that intelligibly. I'm
Are you
sorry.
aware of the district court judge in New York that warned you about the frivolousness of your claim?
I don't believe that the IDEA and 504 claims were frivolous because the OCR did
How about the
find that
RICO
they.
claims?
I really believe that since that's conceded, the more important focus is the IDEA and the 504 claims.
Can I ask you, so are there other parts of your complaint that we can put to one side? Or should we only be focusing on IDEA and 504? Like, I'm sort of not getting this. Like, is there anything else you'd like to withdraw? You've got 10 claims, we're done with 2, you've withdrawn 2. I assume punitive damages goes away with the RICO thing?
We're,
and-
at this point, because the.
You have
the
2 constitutional claims and suits under 1983 for violation of civil rights.
You want to drop
Under the
those?
Equal Protection Clause and the Due Process Clause of the 14th Amendment.
We will concede RICO. At this point,
You
What
could-
about the constitutional discrimination, which doesn't recognize discriminatory impact?
we would say that there
Do you
is.
have a case for that?
We would say that there is disparate impact.
Right,
We
but
do have a
disparate
case
impact
for that.
isn't a claim under the Equal Protection Clause. Do you have a claim that says you violate the Equal Protection Clause by causing a disparate impact?
We would say that their substantive and procedural rights were violated.
Do you have a case that supports that theory?
I can get that in a supplemental
I
brief.
bet
You don't have a
can't.
case now that you know of?
I would have to get that in a supplemental brief.
Well, I'm not asking for a supplemental brief. The question is, at this point, you're advancing a claim under the Constitution for discrimination, and you don't have a case to support the claim.
Well, there is the case.
I think you might be out, you say you don't know what Rule 11 is, but that's count 7 and 8, the so-called constitutional claims.
I would like to mention Charles H. et al. Versus District of Columbia that did afford a preliminary injunction for the 40 incarcerated children that were not receiving in-person instruction during COVID, where they were granted in-person instruction and services in the jail.
Under the Equal Protection Clause?
That was, a good question.
It's
that I
under
can-
idea.
Idea. So primarily, our focus is idea because this is something that
That's
is,
count one,
yes,
and you got 9 more
yes.
that you allege against these what, 6 or 8 people, plus 6 county school boards, or whatever, how many defendants you got in here?
We would just like, my time is up. Would you like me to save for rebuttal, or would you like me to answer that
Answer
question?
answer the question, if you
Okay.
would.
Our concern is that when the rights of these children were violated, that they had disparate impact that caused irreparable harm in terms of developmental delays. These are things that are appropriate for an injunction.
We understand your claim and what your purpose and cause is. The question is, why didn't you just stick with idea? That's the statute that gives rights for special education, and you could argue that the state improperly addressed their interest here. You could have done that, of course. If you did that, then you would, of course, have to go through the whole process of working with the educational system, going through their administrative process. And of course, that's where the district court threw you out on this one for failing to go through that process. But the question, let me ask you, are you conceding on any other counts other than 8 and 9? I mean, 9 and 10?
We will concede on everything but idea in 504. I was hoping to address the exhaustion argument, but I can save that for rebuttal if you would prefer.
All right. We'll hear from you on rebuttal. All right, Mr. Cafferty. Cafferty.
Yes, members of the panel, good morning. John Cafferty for the local school defendants. And I'd like, if I can, to focus on a couple things and bring a few things to the court's attention. One, when you look at in answer to your question about were the students back to in-person learning at the time this case was filed, the complaint answers that question. And the answer is yes. If you look, Joint Appendix 29 through 33, I think it is, the students, and there are 4 students here, so it's not, it was sort of styled as a class action, but we're talking about 4 students from 4 different school divisions, actually 6 different school divisions because they moved around a bit. Large school divisions like Loudoun, smaller school divisions like Amherst. They went back at different times. They were all back in school in person by March 2021. This complaint was filed in October, I think October 12th, 2021. They were all back to school by that point. And one other thing that had not happened at that time is that the administrative hearing process hadn't been completed. In fact, it hadn't been started for some of the students, but there's no dispute about the fact. I mention that in part because it's been a while since we had done the briefing in this case, and in the intervening time, there have been a couple of developments relative to exhaustion. One of them is your decision in the KI case that makes exhaustion essentially a 12B6 issue instead of a jurisdictional 12B1 issue. We don't need to worry about that here because both in their appellate's brief and really in the complaint, they make clear that the administrative process was not finished. In fact, it had barely even started at the time this complaint was filed. That's important because, as I mentioned, you have 4 different students. They have different disabilities. One of them has autism. One of them has other health impairment, cognitive disabilities. In different situations, as has been pointed out, what the impact of virtual learning. I mean, this is a claim that you could have in the administrative process. We had many of them. They're finally sort of winding down now. We gave you some of those sites in the court. But this is exactly the kind of case where you would want the plaintiff to exhaust the administrative process, the administrative hearing process, and really, the other important intervening development was the U.S. Supreme Court's decision in the Perez versus Sturgis school district case. So I did want to talk about the applicability of that. That case focuses on So now we're down to IDEA and Section 504, and I'm not clear about ADA. But in any event, what the court there focuses on, assuming that, like first under Fry, you have to look and see, is this basically, is the corpus, is this the gravamen of these claims the same? And of course it is. The 504 and the IDEA case claim, and really even the ADA, they all sit on top of each other factually. So then the question under Perez is, are you asking for any different remedy than you can get under IDEA? That's what 20 U.S.C. 1415 L says. And the answer here is absolutely not. This is not a case, Perez was a case where there was a compensatory damages remedy that was sought. Not the case here. And you've obviously looked at the complaint, which I think starts at the remedy. The complaint is quite lengthy, as you know. The remedies section, I think there are 16 different subparagraphs, starts on page 71 of the joint appendix. And if you go through there, the things that are being asked for, compensatory education, certainly available under IDEA. Attorney's fees available under IDEA. For that matter, in an appropriate case, even things like declaratory and injunctive relief would be available. All the remedies that are sought in this complaint are ones, and of course,
What about the nominal damages?
well, the nominal damages, and we get back to punitive damages. Nominal damages is interesting. The first thing I would say is, nominal damage is not an issue reached or apparently raised in the Perez case. So,
Also not raised in the plaintiff's brief on appeal.
well, correct, Your Honor, correct, Your
Or in their
Honor.
letter about Luna Perez.
And so what, and then furthermore, what I would say is, this court has not ruled on that. There's not a ton of case law because frankly, the idea of nominal damages, or this analysis of are the remedies precisely the same really comes to us only with the Perez case, certainly in this circuit. But to answer your question, if you look at
Well, what are the nominal damages for? I mean, nominal damages are not available for everything. I mean, we recognize, I think, in breach of contract cases.
Right.
But what is the theory here?
Well, the theory, and it would obviously be a plaintiff's theory, but I mean, as I understand it, it would be recognition of the infringement of some right. And if you look at your decision in the G versus Fort Bragg.
Can you get nominal damages under IDEA?
Well, I started to say, this court has not answered that question expressly.
Have other courts?
Well, the Fifth Circuit in a case called, a 1995 case called Sally versus, I'll find it, the Sally case has approved an award of nominal damages. I will tell you that there's a Ninth Circuit decision from 2012, obviously predates Perez, that's to the contrary. In terms of your law, the closest thing we have is the 2003 decision in the G versus Fort Bragg dependent schools case. That's the case, importantly, that by which this court authorized the award of compensatory education, because that's also something they seek. And if you look at the discussion there, there's a discussion of a couple of federal cases dealing with nominal damages. And what the court basically makes the analogy to, well, the purpose of nominal damages is to
Justify punitive damages.
well, that's,
Or attorney's fees.
well, attorney's fees.
If you
attorney's
get
fees.
you get
Exactly.
nominal damages in a 1983 case, and as a result of that, you can get attorney's fees.
It's to
That's the
pick a
hook.
winner for purposes of attorney's fees. And there's no dispute that
Could you get?
attorney's fees are
Could
available.
you get attorney's fees under IDEA if the court determined that the child was not getting the FAPE, but didn't award any damage? and directed the school to provide a different program. Would a person be a prevailing party and get attorney's fees?
That would be for the court to decide, but I would,
But I mean,
I would
is
say,
it authorized under the statute?
I would say yes. I would say yes. The court has, significant latitude to.
But you have to be suing them individually. Under 1983, you can't get nominal damages if you sue them in their official capacity, but you can if you bring individual action. But
Fair enough.
does that distinction apply in the IDEA?
I'm not sure I quite,
Naming the public official in their official capacity and in their individual capacity, two different things.
well, I would say for purposes for IDEA purposes, there isn't any individual school.
There's no individual capacity.
Correct.
It's all official.
Correct.
So that would, normally you wouldn't get damages at all. in that kind of
Right,
situation.
right. And if you look at the, as I said, in the G versus Fort Bragg case, if you look at that discussion there, they essentially say that the purpose of nominal damages is to assign a winner for purposes, or a prevailing party for purposes of.
A fee shifting provision.
For fee shifting, exactly. But it would be a pretty unfortunate result, I would submit to you, Your Honors, if someone, by the expedient of adding a throwaway nominal damages claim, could avoid all this administrative apparatus we have to try to develop a record for these cases for the benefit of the court. I see my time is up.
All right.
I'll yield to my friend from.
I understand Mr. Minot, or Minot?
It's Minot, Your Honor.
Minot,
But I've been called much worse, so.
sorry.
Your Honors, may it please the court, I'm Jordan Minot. I'm here to represent the Virginia Department of Education and the Superintendent of Public Instruction. I'm joined at some distance by.
Could we just, before you get into it, just address this question? It seemed to me that if it's just against officials, we shouldn't be talking about nominal damages, should we? Wouldn't you be immune from that?
That's correct, Your Honor. I'll also add to the discussion that, especially with respect to the 1983 context, the Supreme Court in Farrar versus Hobby, which is a 1992 decision, said that an award of nominal damages by itself without compensatory damages was not enough. It was enough to confer prevailing party statuses for the purpose of 1988, but not enough for attorney's fees under 1988. So nominal damages are different in kind from compensatory damages. In that Supreme Court case, the court discusses how the award of nominal damages and without compensatory damages, in fact, demonstrates that the plaintiff was not able to prove compensatory damage, or that they were damaged in a way that could be compensated. So that kind of goes to the nominal damages are treated and should be treated differently from compensatory damages.
But your clients are sued under 1983, is that correct?
That's, as far as I understand, that's correct.
But she says she's going to throw all that out.
That's right. So my understanding is.
You haven't heard anything like that till today.
That's correct, Your Honor. The only claim that we believe was conceded before today was the Virginia Human Rights Act claim on JA 1353, footnote 1. That's the.
Count 5.
That's correct, Your Honor. That's the preliminary injunction reply brief by plaintiffs. They conceded that. That was the only claim, as we understand it, that supported punitive damages.
So as of now, you're sued under 1983 and under RICO.
And under counts 1 and 3, which are the IDEA.
Yeah, but
Yes, sir.
the one she's going to throw out, or says she's going to throw out.
That's our understanding, Your Honor. And so we contend that all of the counts, with the exception of counts 1 and 3, are barred by sovereign immunity with respect to the state defendants. That's true. That was true whether or not they're still alive. That includes the constitutional arguments, the 1983 claims, the RICO claims.
And the state defendants are the Virginia Department of Education and the Superintendent of Public Instruction.
That's correct, Your Honor.
But they sued Mr. Lane, and he's the former superintendent.
That's correct, Your Honor. We've now been through 3 superintendents of public
So
instruction
they've been
since this case.
substituted, the others?
We've first substituted Jillian Ballo, who was the superintendent of public instruction when this case came on appeal. It is now Lisa Coons.
Are they all in their official capacity?
That's correct, Your Honor.
So that it wouldn't make any difference with respect to the immunity issue then?
That's also correct, Your Honor. I mean, they're additionally
So
barred by
what
sovereign
you
immunity.
understand is that counts 1 and 3 are the open counts that need to be addressed.
That's right, Your Honor, and we think that they are barred because they failed to exhaust their administrative remedies. Plaintiffs in their complaint conceded that they had not completed the administrative process at the time that they filed their complaint. In fact, some of them had not started their administrative process by the time they filed their complaint. They argued when they filed their complaint that they needn't exhaust their administrative remedies because doing so would be futile. They argue on appeal that they, in fact, now have exhausted their administrative remedies, and that is sufficient. Neither argument is availing. They were required to exhaust their administrative remedies that were available to them. They failed to do so. Artful pleading by...
I'm sorry, they were required to exhaust their IDEA administrative process, is that what, okay.
That's correct, Your Honor. They failed to do so, and they
But
cannot...
all you want us to do is affirm Judge Moon.
That's right, Judge King.
We don't have to get into these details as to each count or anything. If we affirm Judge Moon, that
Well, what do you
takes
understand?
care of it?
What do you understand Ms. Fuller has conceded today? She said she was withdrawing all claims except, I didn't quite hear, 1 and 3, is that Ms. Fuller?
Yes,
That's
Ms.
1 and 3, right?
Judge Niemeyer, that is 1 and 3, yes.
Yeah, okay, I just wanted to understand that. So the understanding among counsel here in the courtroom is that we should address 1 and 3.
That's right, Your Honor, and to Judge King's point, I think that you can exactly follow what Judge Moon did with respect to those counts, which is note that plaintiffs conceded that they did not exhaust their administrative remedies. They do not meet a futility exception, and even post-Luna Perez, they do not meet the standard that was discussed in the Supreme Court there because they did not plead either compensatory damages and that their punitive damage claim has been conceded.
All right. Thank
If there
you.
are no
Have
further
anything
questions, we
Yeah.
ask you to affirm. Thank you, Your Honor.
Mr. Hearn?
Good morning, I'm David Hearn on behalf of the Chesterfield and Chesapeake School Boards. In my limited time, I was prepared to address Judge Moon's ruling in the district court below, dismissing equal protection, the due process, and the RICO claims on 12b-6, but I understand for the first time today that the appellant's counsel has indicated that the appellants are conceding that, and therefore, in light of that, I believe that Judge Moon's ruling must be affirmed. I'm happy to answer any questions. I'll address anything the court would like me to, but in light of that, I don't know that there's anything to be said. And I'll be happy to cede my time to my colleagues if that would be helpful to
All
the
right,
court.
thank you. We'll hear from Ms. Fuller, rebuttal. And you're free to, you wanted to talk about exhaustion and so forth, and you're free to do all of that.
Thank you. I'd love to talk about exhaustion. So I think it was a little bit of a misstatement that we conceded that we failed to exhaust. That was not our argument. Our argument.
We understood you did not concede that. We
Thank you.
understood you're withdrawing all the counts except 1 and 3.
Yes.
And 1 and 3 were dismissed by Judge Moon based on exhaustion, and you're preserving that point.
Yes, absolutely. And I would like to say that I feel there's been a bit of a, not mischaracterization, but under Perez Sturgis, it is defendant that has to prove that the plaintiffs did not exhaust. It is not the plaintiff's burden to prove that. And we also said in our argument that that we did not have to exhaust because there was an exception, that because of the stay put requirement under 1415J, that we met the requirements for the exemption. So the
I'm sorry,
fact
this
that-
is the futility exception?
Yes.
Okay.
Yes, well, also under futility, I would disagree with my colleague that the hearing officer does not have the ability to grant the injunctive relief that we're
Well, let me ask you on
requesting.
that question. That's an
Neither does an
interesting.
Article III court, but go ahead.
Did you have a question?
No, I didn't. I just had a
Oh,
snide
yeah.
remark.
My question is, we have COVID, and we have a situation where these defendants have determined we can't have in-person contact because of the contagiousness. And so they have remote learning for everybody. The question is, what would you expect additionally to be done for persons with disabilities in the remote learning context? And that's because it seems to me that has to be, if this was ongoing, that would have to be something you would have to address or want, right?
So in the individual administrative context, IDEA contemplates that a student who is denied a FAPE, a free appropriate public education, would be able to go to the hearing officer that would get relief in terms of a
No,
placement, a
I'm
change
trying to
in.
figure out what, that's exhaustion. I want to find out substantively. We have a person with a disability at home with a computer, and it's on the program. But your argument, as I understand it, is that's not enough for persons with disabilities. There has to be something more provided.
It's
Is that
not the
right?
same if you have physical therapy or occupational therapy or even speech therapy to say that you can provide that virtually without actually being in contact to
Okay,
provide the
that leads
therapy
to
in
my question
person.
now. What would you have wanted them to do? In other words, do all of those require in-person contact?
Yes, and we're saying that
But
that was
these-
the disparate impact, that just because a teacher can talk to you doesn't mean that a
understand that.
therapist can provide services, and that's
I'm trying
why.
to stay with in the context of the COVID.
That-
And so
yes.
you wanted to have persons visiting these
Yes.
persons with disability,
Yes.
even though we had COVID restrictions?
Yes, nurses
mean-
had to provide in-person,
Well,
so.
nurses were, and they were susceptible, nurses were being injured too. I'd say the real
these-
question is, we had a pretty
These children
serious emergency. Yeah.
had developmental delays that will impact them for the rest of their lives
Oh, I
because they
understand
did
that.
not receive in person, and that was their guarantee under IDEA and the 504. So that's why there was the need for the declaratory.
Okay, so let's
relief
stay
and-
with what you're pointing out. You suggest that there could have been visitations to these students
Yes.
by persons to address their needs individually.
Yes, and
As-
OCR
just a
found
minute, Let me
that.
ask my question. And they would be treated a little bit like nurses were in the hospitals at that time. Could that have been something that you could have requested in the process, the administrative process, in meeting with them and discussing it?
The hearing officer has no authority to grant that a school district provide in-person, or the Virginia Department of Education provide in-person services, and that's the crux of this argument. And that's why it is so crucial, because these children faced developmental delays and regression that they will never get back.
I guess, I'm sorry, why couldn't an administrative officer, not
it-
under these circumstances, have said, okay, fine? we're
It's
gonna
not
have to
relief
send
granted
someone
under IDEA. They do not have the ability to force a school district to provide in-person services.
Well, maybe not as a general matter, but I guess I'm just not seeing, you think it's a reasonable argument, treat the teachers like nurses and send them in just under these emergency circumstances. I guess, what are you citing me to for the proposition that the hearing officer could not have considered that?
Because the OCR stated that the children had rights to receive their services as written and implemented in their IEP.
Right, that's why maybe you should have, that is answering the other question. Now you're telling me why an administrative officer should have been able to order the teacher to
No, I'm saying
go
they
to the
cannot.
home.
They do not have
If
the
they cannot,
ability.
then
Why
what
not? What are
relief
you
are you going to
citing
get?
me for?
I mean, you're sort of cutting yourself out of any potential relief in court.
That's why we needed the federal courts to do an injunctive relief, because that's not something.
I just want a citation. Like, if I'm trying to think about this, like someone might write about it, and it's not in, like, what is the citation that I use for, we could not raise this? Because,
Well,
is there a law or something? I
Well-
really don't know.
Well, first of all, if you're talking about exhaustion, why it would not fall under typical exhaustion,
No, I'm
that would be
just
Wagner versus
asking,
Board of
you say-
Education.
It's I only have one question, and I bet there's a really obvious answer. I just want you to clarify. You say a hearing officer would not have had the authority under the law to order the in-person visits we needed as sort of an extreme response to an extreme situation. That could not have been done. And then what's the citation for that?
So under IDEA, if you just want to talk about what, it states what the relief is that you can get, compensatory education.
Why
a
isn't
change
that
in-
compensatory education?
Because that's for the failure to provide the FAPE. That
But you're
doesn't,
saying they're not providing a FAPE because they're at home and they can't get the learning they need. I don't understand why this wouldn't fall within normal compensatory educational services.
Judge Harris, I'm sorry if I'm not being clear. I'm trying to clarify this. So compensatory education addresses the failure of the school board to provide the student with an education. It's backwards looking. We're stating you shouldn't fail them in order for us to have to go back and have regression that's irreparable for a student to get their services under their
Question is
IEP.
that you're missing the question. The question is, why can't a hearing officer provide that remedy that you're requesting?
Because they
And
cannot.
you said they can't, and all we wanted was the citation that says a hearing officer does not have that authority.
Under IDEA, a hearing officer cannot dictate to a school board that they provide in-person services. They can only
Where
give.
does it say that? Is that in the law somewhere? Like, does IDEA say
It like
that?
states what is relief under IDEA.
So this, your argument hinges on the premise that under these circumstances, in-home or in-person education could not have been considered a compensatory educational service. That's your argument.
It would be something that would not prevent the harm in the first place, which we were trying to do. We're not trying to compensate a student that now you're 2 years behind in reading, now you can't speak properly, that you can get compensatory services for that. We wanted to say, please don't fail these students by not implementing the services as written in their IEP.
Well, what can the hearing officer do? I mean, why do you go through the process?
That's the whole point of, there's the exception to exhaustion, because they cannot. The hearing officer cannot provide the relief. That's why we're saying
What can the officer provide
They
in
can-
that context?
Okay, they can provide a private placement, a change in placement. They can provide compensatory education. And they cannot say that a child should have in-person services. That's not within the realm of what a hearing officer can implement.
So-
Plus, under exhaustion
So
also,
if they can't do it, and you're asking us to order them to do it,
no, we're asking you to do an injunction that if there's,
but how can you, if you concede that they can't do it, why would a court be able to do it?
you would be able to dictate that if there is a change in placement, that they would implement the IEP as written.
Can I, so if like, I am not in
You said it's
ID.
not written
Well,
to do that.
If,
You said it doesn't let you do that.
I don't know if I'm understanding you correctly. Let's say we have an IEP. It says the students should have 30 minutes of occupational therapy in person a day. It should be a push in or push out.
Okay, and then say that student like breaks his leg and he's gonna be home for a couple of weeks. You're saying there's, under no circumstances could a hearing officer say, I guess the physical or occupational therapist is gonna have to go to the kid's home for a few
The
weeks.
hearing officer could determine that there's been a change in placement. The hearing officer could say that the school district did not provide the student an education if they didn't receive the services.
So say it's day 2, he's still home with his broken leg. On day 1, he didn't get the services. He can't go to a hearing officer and say, make the person come to me.
Correct.
That's.
Well, let me ask
seems
you
unlikely.
this, I have this problem then. If you can't get the relief of having personal visits, that's what you told me that these children should have been getting during
Yes.
COVID.
Yes.
And if a hearing officer cannot order that, how can we order it?
Because that would be
What authority do we have
injunctive.
under IDEA to
Like in the
order it?
DC case, the children were in jail. They were not
No,
getting in-person services. The court ordered,
I want
go
you to-
in and provide the services, because otherwise, they are not going to be getting their services as written in an IEP. But that was not an administrative
I
level.
thought you told me that IDEA doesn't authorize providing for in-person visits.
The IEP, the hearing officer cannot
What's the next step
compel
after the
a
hearing
school
officer?
district to do
What's the next
something.
step after the hearing officer? You have a hearing, don't you?
So if you lose at the administrative level, you have a choice
Not the
of going to
administrative.
state or federal court to appeal.
You know, isn't there another process after the hearing officer?
There's no SRO in Virginia.
So the hearing officer is your exhaustion area.
Yes,
And you're saying the hearing officer did not have authority to give you the relief you wanted.
yes,
But yet you're saying we have the authority.
because you can give injunctive relief, as the court did in
But we need to have
DC.
substantive authority for injunctions. We have to order somebody to comply with the law, and you say the law doesn't require that.
No, we said the law didn't require exhaustion of the
No,
administrative
I'm
remedies.
talking about individual visits. You want us to order individual visits to these students, and you say a hearing officer cannot order it because IDEA does not provide for that.
Your Honor, if I may just add one more point.
Can you
kind of
just answer my question?
I am going to answer it, Your Honor. Just one more point. So also in terms of futility and the inadequacy, if you have thousands of students that all need in-person services, that would flood the administrative hearing officers, and there would be no way for administrative hearing officers to grant in-person services to thousands of children. That's why we were asking for
But
the
you're
relief that we
saying
did.
The statute does not authorize a hearing officer to provide in-person visits.
No. Well, I mean, they can
You
say
agree?
that the failure to do it was a denial of fate, but they cannot force or
All
enjoin
right, so
the,
my just question is, where do we get the authority under the statute to order what the hearing officer couldn't order?
you get it under a preliminary injunction.
That's the remedy. The question is, what's the substance that authorizes us to order them to have in-person, if the statute doesn't authorize that?
That there is a right to have your procedural and substantive safeguards protected under the IDEA through the IEP.
I mean, if the statute does not authorize a person with a disability to have a Cadillac chauffeured trip to school every day, would we have authority to impose injunction and say you have to do a Cadillac service trip to school every day?
IDEA provides procedural and substantive safeguards for parents through the IEP, which
Okay,
is,
you answer so generally. I'm asking you particularized hypotheticals, and you keep ducking it with some generalized thing. My question is, this is my last chance, and I'll be quiet then, give you a minute. If the hearing officer has no authority to order in-person visits because it's not provided in the statute, where would a court get the authority to order that?
so there's a violation of a procedural and substantive right that's causing irreparable harm.
So you're being general. I'm saying, I want you to know, can I order the personal visits to all the students?
I would believe that the court has the ability to
And we
order
would
the
have to rely
provision
on-
of the enforcement of the IEP as written to provide the in-person services.
I thought you said IMP doesn't authorize that.
That's exactly what you said.
No.
If they did, if the IEP, if it did
No,
authorize
I
that,
think,
then-
no,
then
I said
administrative
IEP, not
authority.
IDEA. I'm sorry, was there a confusion in what I stated?
Well, all we have to decide is whether Judge Moon was right or wrong.
So the district court erred. We are saying that the district court erred by stating that we failed to show the disparate impact.
Well,
We would like-
that's, a disparate impact is under another, it's under discrimination statute, which we're not addressing anymore.
Okay.
Yeah. All right, we've gone quite a bit beyond. We'll adjourn court, sine die, and come down and greet counsel.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.